from the UAE. And also, it's a great pleasure for us in Al Tamimi to host the LOS event. This is the third time to host this event, and each year actually we have a new topic to be discussed. And this year, I know actually the hot topic is the Decree 34. Everyone is looking forward to hear about the views from the practitioners, to what extent this decree will help Dubai to grow more as a seat or one of the preferable seat, arbitration seat. Plus, actually, definitely the practitioners, they have some doubts. They would like to clear some points about the decree. For me, I will talk now under my hat as a litigator. We face lots of issues, actually, although there are lots of developments, not only in UAE, but in the region. As you remember, in 2018, we had the federal law. Saudi is moving positively towards arbitration, and Saudi Arbitration Center, they are doing a great work to raise the knowledge and to encourage people basically using the arbitration as a mechanism to solve their disputes. Plus the other countries in the region, definitely all of them, they are basically working to encourage the arbitration more and more. With the whole developments between time to time, we face the problem with the decisions by the court, because having the arbitration and pushing the people to use the arbitration as a mechanism is a good step. But when you will have also some decision, especially the negative decision, I don't want to be negative here, don't get me wrong, because there are lots of developments, especially with the new federal law. Actually, the trend is positive in general. However, I'll be going to touch base on the things related to our topic. We are talking about the arbitration agreement, or the law governing the arbitration agreement. I believe there are doubts with the courts, not only now, even previously, actually, before applying the federal law. I remember one example, actually, there was a decision, or two decisions, actually, partial decision and final decision, issued under the London Maritime Arbitration Association against a party based in UAE. The arbitration was seated in London. A sole arbitrator issued the partial decision, and the claimant brought the dispute to enforce it in UAE under the New York Convention at that time. And the normal tactic by the defendant, normally using the guerrilla tactics, was raising the capacity issue, that the manager who signed on behalf of the defendant doesn't have the authority. I remember actually the court, even the Court of Cassation in Dubai, they issued a very smart decision on that time by saying that, hold on, the capacity, you should claim it under the law of the seat and not under the law of the UAE, because it's a foreign arbitral award. Although the defendant is based in UAE, but the seat of arbitration is London. So you have to prove that the manager doesn't have the capacity under the London. But what happened with the final award between the same parties, the decision by another court, which was a Court of Cassation, but another judges were sitting, they overturned that decision and they accept this challenge. They annulled the award based on the lack of capacity under the UAE law. So you can see basically two decisions between the same parties, and this is due to the lack of, I don't want to say, lack of knowledge, to be very frank with you. Maybe there is some issues with us as a practitioners because we are not involving the the judges in our events. And I can blame also the judges, to be very frank with you. Most of them, they are not willing to participate in these events. And this is it's a major part of the problem, honestly. So having a good law, I'm sure that our law, the arbitration, the federal arbitration law, is a strong law, actually. It's a very strong law. It's one of the developed law. But it's a matter of how to apply the law. The law, for example, talks about the seat and differentiated between the seat and the venue. The arbitrators, they can conduct their hearings anywhere, and they can agree on the seat. So there is a difference between the seat and the venue, and this is very obvious concept. Yet Dubai court actually, even after the federal arbitration law, they mixed. We have the decisions where the parties agree on DIFC, CIA rules, but the seat is Dubai. And they will simply reject the case due to the jurisdiction, and they will ask you to go to the DIFC. Nothing to do with the DIFC, the seat is Dubai, although the rule is DIFC or CIA. So the mix, these are very simple concepts for the arbitration practitioners, but yet the judges are making a mistake. And it's not one decision, more than maybe 3 decisions about the same concept. They don't know the difference between the seat and the venue, or the rules sometimes applying for the arbitration. With the new decree, the good thing of the decree, overall, I'm actually very positive towards the decree 34, because it's good to have one arbitration center. And since long time, we were calling that we need, if we would like Dubai to compete with Paris, London, and Singapore, we should have one arbitration center, and we should focus on that. And I have a hope here, but it's too late. Rather than basically, because right now, actually, if the parties agree on Dubai, then Dubai court will have a jurisdiction, and the federal law will apply, and the default seat is the DIFC. If they are silent about the seat, then the DIFC will have the jurisdiction. I mean, DIFC courts, and the DIFC law will apply. I wish if we had one court, basically a combination of judges from Dubai court and the DIFC to deal with the arbitration in Dubai. It was the ideal to have one court. Why? You will have a combination of common law and civil law jurisdiction sitting under one umbrella. They can learn from each other. Because honestly, with the development, I believe lots of issues will happen. I was going through Michael's presentation. Really, he raised one smart question. How about if the jurisdiction is DIFC and the applicable law or the governing law is UAE? What will happen with issues like a capacity? Still, we don't have a clear vision by the court about the capacity. Still we are suffering from this topic. So this is very smart question, and we need here also to debate about it. But I will put, Michael, if you allow me, my recommendation, it could be one of the solutions. I'm not sure whether it will be a solution or not. But still, they didn't nominate the members of the courts of DIAC. They nominate the board. I believe the government should consider having a combination of international practitioners to sit in the court from the civil and common law. It might solve some of the issues, in my view, and not all of the issues. But overall, I believe the IFC court will be able to deal with the case, even though if the governing law is the UAE law. But these issues really we need to consider, because some of the issues are principles issues by the Court of Cassation. How the DIFC will deal with it, it's a question, and we will wait to hear from the panel. Without taking much, I would like to thank you once again for being with us, and I would like to introduce the panel briefly. Actually, we have a well-known QC, Michael Black. We have Hafid Berji, the president of the laws, Nicolas T. He's a partner in Alim. And of course, Sarah Aranjo, a partner in Al Tamimi and Company. I will let them to debate and we will try to learn from them. I'm sure that they will add a lot to this event. And at the end, thank you once again. And the floor is yours, Sarah. Thank you so much.
Thank you very much. And good afternoon to everyone. And thank you for joining us today for what I would like to echo Dr. Hassan's word. It's a very timely and yet, I guess, also controversial, if I can say, topic. And we thought when we were discussing the decree that it would probably merit the addition of a perspective that would be sort of unique in light of the latest developments on a technical topic, which is not unfortunately always looked into graciously. And so we will obviously be looking at different perspectives internationally and try to draw on certain probably comparative practices from other jurisdictions and how these could probably fit into play in light of the latest developments to the arbitration landscape in the Emirate of Dubai. Just to start off by saying that the topic of today's panel is the new Dubai and the law governing the arbitration agreement, Halla, Wayn. And so for those of you who are not Arabics, I would say that this is coming from this obviously Arabic, but this is particularly a Lebanese dialect, and not because the decision, I think, the question was just quite controversial, involves the Lebanese party, but the expression actually is the Lebanese equivalent of the very famous Latin expression, "Quo vadis," which means "where are we headed?" And ironically as well, it is also the name of a very famous movie, a Lebanese movie, which received the People's Choice Award in 2011 at the Toronto International Film Festival, and which also premiered at the Cannes Festival in France, and which talked about conflicting also views of women in Lebanon trying to fight certain religious beliefs. So I think it married well in a way, I hope at least, with the debating question. I'll briefly like just to introduce everyone, even though, as Hassan alluded to, everyone is particularly known, but allow me maybe just a few brief introductions, and I'll just go with the order of seating. Nicolas Che is a dual qualified English barrister and French avocat, and chairs the international arbitration practice at Alim and Associates, and is presently based in Abu Dhabi. He appeared before the UK Supreme Court in the recent Kababshi case concerning enforcement of a foreign arbitration award under the New York Convention, and has contributed to the UAE chapter of the forthcoming IBA report on the enforcement of arbitral awards against a non-signatory. And on his right is Hafiz Virji, who's the president and co-founder of the Lost Dispute Resolution, and also serves as an independent arbitrator at Virji Arbitration. He is the co-general editor of the Lost Guide to Arbitration Places, known as the GAP, which I invite you all to have a look at. It's a very comprehensive, and not because I'm the editor for the MENA region, I have to disclose, not because Dr. Hassan sits on the board, but it's a very comprehensive publication which provides an in-depth analysis on really practical questions and implications as to doing arbitration, and the analysis is done on a jurisdiction by jurisdiction basis. So please feel free to access the Lost website and download a complimentary copy of the GAP. And then last but not least, for sure, Michael Black, UC, who's an international disputes lawyer specializing in international arbitration and offshore litigation, both as advocate and as an arbitrator. He was, quite to his honor, the first barrister to be admitted to the bar of the DIFC courts, and appeared in both the first trial shareholders dispute and the first appeal against freezing injunction. So welcome once again to all of you. And just to try and put things a little bit into perspective, as Dr. Hassan has alluded to, we are really transferring into the new Dubai, into the new dimension of the new Dubai. And often there's a topic which is quite surprising, is that the answer to such a fundamental question, which is the law governing the arbitration agreement, is not necessarily always sought out, and particularly at the time of the drafting of contracts, and particularly arbitration clauses. And as many of you would know, there is often a tripartite approach to laws as part of any contract and any dispute resolution mechanism. So you often look at the governing law, you often look at the procedural law or the courier law. And then third, you often look, which is often foregone and not looked at, is the law governing the arbitration. And this is a fundamental question, which is, as I said, not often looked at or considered in depth. And I think many of you might not have even factored it in at the time of the drafting of an arbitration clause. But if we look at Article 5.1a, which we'll discuss today in depth, the New York Convention, the absence or incompliance or the inexistence or the invalidity of an arbitration agreement under the law, obviously, that will govern it, can have serious consequences that obviously it can lead to set-aside, which then obviously leads to the question as to which law then governs the arbitration agreement. And as you will see, as probably as simple as that question is, unfortunately, there is a dichotomy and even a pluridichotomy in approaches and a collapse and a fragmentation in the answers. And we can see how a same case with similar facts can have contradicting judgments applied, particularly I would refer now to London and Paris. So let us start off by Nicholas. Nicholas, you were involved obviously in the now very popular, I would say, cat food versus kebabshi. So can you provide us just with a little bit of an overview? We know that what's interesting is that the award, we understand, was upheld in Paris.
Yes.
And then very recently, on 27 October, the Supreme Court of the UK confirmed annulment.
Not annulment, they refused to recognize and enforce under the New York Convention.
So can you provide us with an overview
Yes,
as to what and how we sort of come to an approach as to the collapse in the approaches pertaining to a refusal to enforce?
Yes. So Hafez is going to talk to you later, I know, about Enker and Chung, which underlays a lot of what is different in the decision of the UK Supreme Court compared to the Paris Court of Appeal in the Kebabji case. I'm going to call it Kebabji because that's the one that, that's the name it was called in England. Now, what the background here is there was a 10-year franchise for the territory of Kuwait. And what ended up happening, as I'm sure you'll see with many of your commercial clients, is that there was a bit of reorganization of companies during that 10-year period. And so the initial franchisee who had signed the 10-year franchise agreement restructured and reorganized in a corporate sense, and a different mother company appeared, which then effectively performed for the remaining 5 years of tenure the franchise agreement. Now, my colleagues, Alan, but before I joined, brought an arbitration against that mother company on behalf of Kebabji in respect of various alleged breaches concerning the franchise agreement. And there was an ICC award, which was issued in December 2016, which we then took to the UK to seek to enforce. At the same time, the award debtor, so COOT, applied to the Paris Court of Appeal, the court of the seat, competent court of the seat, because it was a Paris seat arbitration, to seek to annul the award. Those proceedings culminated in the decision in June 2020 of the Paris Court of Appeal, where it upheld the award because adopting the French a-national approach, and I'll come on to that a little bit more in a moment, the arbitration agreement is treated as completely autonomous. And so if you don't have a specific reference within the arbitration agreement, and this has been confirmed by the Supreme Court, by the way, in England, to paragraph 89 of their judgment in Kabanji, if you don't have an express choice of governing law applicable to the arbitration agreement within the arbitration agreement, then the French courts, as a matter of French law, will look at what they think the common intention of the parties was, and they will treat the arbitration agreement as completely autonomous and independent. Now, on that basis, simply because the mother company of that way had performed 5 of the 10 years of this franchise agreement substantially, the arbitrators had unanimously held in Paris that there was a valid arbitration agreement extending to this non-signatory, and that was confirmed by the Paris Court of Appeal. And following the French court principles, which again we've been reminded of in the UKSC's judgment, and I'll come on to that because it's important. The reality, I think, is that the Court of Cassation, because there is an appeal to the Court of Cassation in Paris now, is likely to produce a similar result to the Paris Court of Appeal decision.
Yeah, and that takes us a little bit to the evolution of the approach, which we will shortly obviously discuss.
Can I make just two points very quickly about the Kabanji UKSC decision? And this is very much from a New York Convention perspective, because here, the English court was the enforcing court, looking at Article 5.1a and asking itself the question, what was the law to which the parties subjected their agreement, which under 5.1a means the arbitration agreement, not the main contract, or failing any indication thereof, the law of the country where the award was made will be the applicable law to the arbitration agreement. Now, what is particularly notable, I think, in terms of an enforcing court decision, because of the, if you like, prevalence of English law and its persuasiveness, if not its binding nature for many enforcing courts to signatory states under the New York Convention. What's important is that paragraph 35 of the UKSC judgment, the Supreme Court read Article 5.1a as being something which could give rise to an express or an implied choice before you get to the default rule, which is seat law, usually seat law of the country where the award was made. And particularly important was the fact that, if you like, fortified by the Anchor and Chubb decision and the rather lex contractus approach, wanting to achieve consistency, because how could parties, international parties, choose 2 systems of law to govern their contracts? I think the English policy perspective is looking at trying to achieve coherence and certainty. And so what the Supreme Court did was to read any indication, if you don't have an express agreement, as being something which could indicate the governing law of the main contract, and therefore would be likely, potentially in many cases, practically, to displace the potential default, well, the supposed default rule under Article 5.1a, which is the law of the seat. Because while it is unfortunately very, very seldom the case that parties choose a law applicable to their arbitration agreement specified in the contract, very often they do choose a main contract governing law.
Thanks a lot, Nicholas. And I think this relates a little bit to the evolution also of the approaches. I mean, we've seen in France from the very famous Hack decision in 1972 up until the 1993 Dalico jurisprudence as well, which has also further clarified the matter and shifted away from a purely conflictualist approach to an approach where it's mainly a national, trying to promote a regime which is arbitration friendly. And we've seen as well, obviously, in the UK, the Halla case, which I think this is the continuity of the sequel as well, in a way, of the Halla case, and trying to first, and I think there is a similarity probably in the facts, and I think just for the sake of everyone, is to try and put things into perspective. Is usually typically given the consensual nature of arbitration. The question also carries a significant importance because of the scope of applicability also, and the manner in which you define the mandate also as well of the arbitral tribunal. And so in the Kalaji case, and as you've can be seen on the slide, the legal question also was, to which extent can you also extend the applicability of an arbitration agreement to a non-signatory? And this is why we come to two different sort of results. And I think that leads to a very important question as well, which is the doctrine, famous doctrine as well of separability and different approaches. Are we talking really about an autonomous, independent, or separable arbitration agreement, obviously from the main underlying agreement?
I mean, I think that's, we might want to go just forward on the slides to put that proposition. There's, if you go right to,
You want to make it go?
yeah, keep on going. Because we can always back up to the map if we want to. So it's a provocative slide, I know.
Yeah, exactly.
So you'll have seen some maps. We may not get to them because of shortness of time, but Professor Dr. Maxi Shearer, having read Anchor and Sharp, embarked upon a little bit of research, comparative law research, to see how many countries do in fact favour the law of the seat or lex contractus, or what other approaches there might be. And that was based largely upon our good friend Hafez's guide to arbitration places. Now, what I would propose to you is that the reality is that the lex contractus approach, which is very much now, of course, the English approach, and will be used in English-derived common law courts in many places, including here. That treats the arbitration agreement as merely being separable from the main contract, and only to be separated if it's necessary in order to find that that arbitration agreement is valid. Now, that's very, very significantly different from certain other traditions around the world and certain other nations who will treat the arbitration agreement as completely independent. We've already given the example of France, which treats the arbitration agreement as being a contract unto itself. Whereas the approach, if you take the more English approach and look at separability, is, well, this is all part of one contract, which the parties have agreed. And so it must be read in the light of the terms of the contract. And the English law presumption in terms of rationale and philosophy or policy, if you like, is, well, surely one law should govern the whole of the contract, including the arbitration agreement, even if that refers to a seat in a third country.
I do think it would be, if we can, well, obviously we're under time chase, but I do think probably, Nicholas, if you can maybe give us an overview of that comprehensive study that Dr. shared.
Yeah, so as you can see, I mean, it's a little small perhaps, but the reason why Professor Dr. Shearer undertook this is because the Supreme Court had said in Anchor and Sharp that it thought the lex contractus approach was the most predominant in the world among nations when looking at the governing law of the arbitration agreement. But in fact, according to her research, it accounts for some 34%, which are in green. So you can see there North America and Canada, you can see England and Wales, you can see many of the other English-influenced jurisdictions, Australia, India, etc. Then, if we go to the next slide, she found that 51% of countries favor the seat-based approach, which is, well, we know, whatever one thinks of it, that the default rule, if there's been no express choice within the arbitration agreement, default rule under Article 5.1a of the New Convention is
That's the default.
law of the country where the award was made, which is almost always the seat of the arbitration. Then there was also the question of the French approach. This is the a-national approach. You can see the hexagon of France at the top, and then you can see the Halla countries, basically, and then some others like Benin, Togo, etc. And that is the approach where you're simply looking at taking an a-national approach and looking at what the common intention of the parties was, evidenced usually by performance. But of course, to be fair to the lex contractus approach, what's that performance on? It's not usually of the arbitration agreement. It's of the underlying main contract. So the final approach is the validation principle, where, for example, Switzerland and Spain, but also Peru, you can see in South America, would approach the question of what law governs the arbitration agreement from deciding which of the laws that could possibly govern it will make it valid. So not necessarily, I suppose, ending up with a decision in respect of which national law does actually govern it, but taking the validation approach. That might have led, for example, in the Kabanchi case, if it was an enforcement in Switzerland, to an upholding of the award, or not an upholding of the award, sorry, to recognition and enforcement being permitted.
And rejecting the challenge.
And rejecting the challenge.
Absolutely. Exactly. And so we can see obviously the fragmentation in the approach, even though it's quite, I mean, I would say not necessarily surprising that you see that there's a prevailing overall approach which favors the seat approach from a sort of quantitative approach. And for that, maybe Hafiz, from an institutional perspective, given the breadth and the comprehensiveness of the gap, we would really welcome your views on mainly the approaches with regards to the lex contractus versus the arbitration seat-based approach, and sort of what are the trends maybe that you've picked up, just to maybe complement what Nicholas has shared with us.
Okay, we'll do without slides. I think
Go back.
Sorry?
Go backwards.
No, so one thing that was interesting to look at in the reasoning of the UK Supreme Court in Enka and Chubb was how did it justify its choice of applying the contract law versus the law of the seat. And while we're talking about an English court decision, because the reasoning is couched in much more general terms, I think the reasoning is valuable for all of us in talking about the law applicable to the arbitration agreement generally. And perhaps as a start, we need to posit certain assumptions. So we've got a contract which has an arbitration agreement, which has where the seat is identified. We don't have any issue between the potential laws involved in terms of validation of the arbitration agreement. And therefore, this really is a question of choice between the law applicable to the main contract and the law of the seat. And here there's a further assumption, which is that we can infer or recognize in the main contract a choice of law, because otherwise the question is completely different. And so if we've got all of those conditions together, the UK Supreme Court put forward 5 reasons why it considered that one should favor the law of the contract, which I think can be regrouped into 3 arguments. And those are, in turn, 1, a degree of certainty and to avoid artificiality. And what the court had in mind in saying that was, if the parties have chosen a law to apply to their contract, what they're presumably saying is this law applies to all of the contract, including the arbitration agreement, and it would be artificial to carve out the arbitration agreement and look at a separate law to govern those terms. And in saying that, the court gives the example of when you assign a contract, you don't write two separate assignment agreements for the main contract and the arbitration agreement. So there's a first point on legitimate expectations and certainty. And then there's a second one on internal consistency within the contract. And the point of the Supreme Court is this: you want all of the rights and obligations under this agreement to be governed by the same system of law. Because otherwise you may have difficult questions to deal with in situations like multi-tiered clauses. Some of you know, just to take an example, the law proposes a model pre-arbitration negotiation clause. So if you've got negotiation followed by arbitration, do those two steps, are those two steps governed by the same law? Is it different laws? So from the perspective of the UK Supreme Court, if you have a choice of law, keep it for everything. And then the third point the court made was coherence. And what it was saying there is, and I'll quote, you want an approach that is consistent with the treatment of other types of clauses whose validity is also insulated from challenges to the contract. And here I'll digress for a moment to refer back to what you were saying about severability. And to continue with the quote, such as choice of law or choice of court clauses. Such clauses are generally presumed to be governed by the law of the contract of which they form part. So those were the arguments put forward by the Supreme Court in favor of the law of the contract. And Sarah, subject to your thoughts on that, I might then consider the arguments in favor of the law of the seat.
Yes, I mean, I just have to add that the argument in support of the law that favors the approach of the law of the seat is obviously also absent. I think that's a very important caveat. It's absent a designation or an agreement by the party on the selection of the seat, which I think most of the time is the case, because for the reasons I mentioned, we tend to forget about designating the law governing the arbitration agreement at the outset. But it is also has been the prevailing view as well in the UAE, and we can go back to certain judgments from the 90s, and I'm talking onshore, not offshore, whereas there has been a more or less of a jurisprudence constante specifying that it has been the preferred approach to adopt the law seat approach with respect to the law governing the arbitration agreement. And we will see obviously with Michael the certain variations and practical implications with respect to the onshore versus offshore. But please, Hafiz, if you can provide your insights on the seat approach for the institution.
Sure. So here, I'd say I was about to say there was a sleight of hand, but that may be a bit unfair. I'd say the Supreme Court put forward certain arguments why one might consider the law of the seat and why that would not apply, and then went on to discuss the situation if you didn't have a choice of law, implied or express. And when you put all of those together, actually, you could say there are 5 arguments in favor of the law of the seat. And I'm not trying to say there's 3 versus 5. I'm not going to count scores here. But just if you take the arguments on their merit, we can maybe then have a show of hands as to what people favor. And so I've counted 5 arguments. One is degree of certainty and proximity. So again, we're talking about certainty, and here the conversation about legitimate expectations get phrased in a different way. If we designated a seat, then there's a chance that the parties intended to submit the resolution of their disputes to the framework, the legal framework of that seat. So you could just as well make an argument about certainty and legitimate expectations in that respect. Relatedly, in when you're looking at these issues from a conflict of law perspective, and you're looking at which is the system of law most closely connected to your contract, one of the key criterion is location. Now, you don't talk of performance of an arbitration agreement the same way as you do of a contract, but the seat provides that location. And here too, you have that notion of certainty and of expectation. I've located my arbitration in this venue from a legal perspective. Presumably, I'm expecting that to determine the choice. Now, what the UK Supreme Court tells us at this point is, oh, wait a minute, you need to look at the content of the law of the seat as to whether it says anything about applying to the arbitration agreement. And I would comment here that it's a sophisticated point, but rather artificial, because, I mean, either, as Nicholas was explaining, the arbitration agreement is separable, and you have a choice of governing law for the main contract, and then the inquiry is moot, or it really is distinct, in which case you're interpreting the contract and you're not going to look at the content of the law, obviously subject to the validation principle. Plus, I would also add here, and I'll echo what Maxi was saying as well on this topic, which is you got a very sophisticated framework that has been posited by the UK Supreme Court. Next step is, will all the courts be able to apply that? And there may be, in the interest of certainty, benefit in having a slightly simpler framework. But I might let you address that question.
Well, I'm going to talk about what's been happening in this choice. Can I have the slide controller?
Yeah, sure.
Because
I mean,
Actually,
I would,
I
I would actually prefer if you.
I would
Go
be,
ahead.
but I was going to say, I'm not necessarily going to be dealing with that on my slides. If you want to deal with that,
Sure.
please
But
do.
what I think, Hafiz, I mean, I think you're about to conclude, so please go ahead before I think I need to invite Michael on a specific topic. So.
Sure. So then I'll just highlight 4 other points. One is, there's an issue of rigor. We don't talk of the arbitration agreement as being separate just to have fun. And within that context of being rigorous, the Supreme Court itself gave an answer to how you might deal with multi-tiered clauses, which I'd imagine can apply more generally. There's also a question of overlap. Some of the issues that are dealt with by the law applying to the arbitration agreement would also come up in the context of the law of the seat. And having 2 separate laws for those same issues could give rise to a number of issues. And maybe just to make that more tangible, if an award is being challenged on the basis that the tribunal did not have jurisdiction because the arbitration agreement was invalid or unenforceable, you're looking at the same issues of what law applies to the arbitration agreement, except that you're looking at it from at a different stage, from a different perspective. At which point you really have to query, does it make sense to have different laws? And then briefly, 2 points on consistency. One is within a legal system and the other is international. Within a legal system, if you're going to take a contract law approach, what you're effectively saying, and then defaulting to the seat when there's no choice of law, what you're effectively saying is we're going to have different solutions in different contexts, and there maybe there's value in having a consistent solution. And in international context, we can have a conversation about the New York Convention and the uniform rule that posits, and whether, as a result, it shouldn't be the case that we should have the law of the seat. I'll keep that short. If anyone's interested in conversation about the New York Convention, I can give a lot more detail, but I think at this stage we can continue to the next topics. And then what I might do is at a later stage come back to then how institutions have dealt with this question.
Thanks very much, Hafiz. And I think now it leads very nicely to our, I think, quite even timelier topic with respect to the applications of Decree 34 For those of you who may not necessarily be aware, I doubt, is Decree 34 came into force on the 20th of September of this year. And it's Decree 34 concerning the Dubai International Arbitration Center. And it's a 10-article decree issued by the government of Dubai, and it was accompanied by a statute of 25-article, which also overhauled the governing structure as well of the Dubai International Arbitration Center. And it's noteworthy to note that the decree has sought to overhaul and restructure the arbitration institutional landscape in the Emirate of Dubai by seeking to have the DAI, which is the DIFC Arbitration Institute, under whose auspices ran the DIFC LCIA Arbitration Center, and the EMAC, the Emirates Maritime Arbitration Center, to be deemed abolished and transfer their rights obligations to the DIAC Center with a transitory period of 6 months. Just before we sort of discuss the impacts of the decree on arbitration agreements, and which ties very nicely to our topic, which is the law governing as well the arbitration agreements and variations, whether de jure or de facto of arbitration agreements. Michael, can I invite you maybe to try and put the foundations in place in terms of legislative and probably certain key jurisprudence, both from the onshore or offshore.
Well, in terms of which laws govern which?
In terms of the relevant laws under the UAE Federal Arbitration Law, the DIFC arbitration law, and obviously certain highlight key decisions that were issued from the 2016 period onwards.
I will do. I think the slides will. I hope.
Will come in handy.
Will come in handy to deal with that too. Actually, I'm glad that Essam's just arrived, because I was walking up and down twice today, and it's a very long way. The gate through the Gate Avenue, and I walked past Karabji twice. The reason I say this, will remember, because it's the only other person like me, I think, who has seen the original plans for the DIFC. Yeah. And the original plans had a monorail running up and down. So I wouldn't have seen Karabji if we'd had the monorail in this morning. But Karabji is obviously extremely interesting, and the international jurisprudence, it plays into what is now the drama that we have here. And it's not actually a big drama. And to be truthful, the message that I want to give, and I think I should underline it, is that the Decree 34, rather the statute, the DIAC statute, solves some of the problems, I think, that Hassan identified in opening this. And I didn't realize that until I actually delved into it. And I think we've had a lot of comment on the statute and the drafting of the decree. And I think once people start looking at it, they're actually going to find positive things in it. We've seen some negative comments, but this I think is a positive takeaway, because there's a lot of confusion, as I'll demonstrate, about the law of the arbitration agreement. And that's going the wrong way. So why is the law of the arbitration agreement so important? Because it affects the validity and scope of the arbitration agreement, and capacity, of course, is a big issue in this jurisdiction. We have a number of different decisions, often conflicting as to whether or not an individual has a capacity to sign an arbitration agreement within a particular company, a general manager is authorized or not. It affects whether somebody's actually a party to an arbitration agreement, whether the court will stay proceedings to allow arbitration to take place, what relief is available from the court, and of course, challenge and enforcement to the award. So we have the federal law, and I put up Article 4 of the federal law, because I just wanted to emphasize the words there, which emphasize the capacity issue that we've encountered in this jurisdiction quite often. Arbitration agreement may only be concluded on pain of nullity by somebody with specific authority to arbitrate. And that's given rise, in conjunction with company legislation, to a number of challenges to awards and annulment of awards. Article 6, we have the doctrine of separability we've dealt with, that the arbitration agreement shall be in writing. And Article 8 deals with stay of proceedings unless the court is satisfied the arbitration agreement is void or incapable of being performed. So again, we come back to the validity of the arbitration agreement. And we have challenge again on the basis there is no agreement in existence. And enforcement is also denied on the same ground. So we come back again and again to the importance of the arbitration agreement and its validity. The DIFC law, which shares a common DNA with the 2018 law, because they're both model laws. They've been both modified slightly, so they are similar in a number of ways. But I just highlight one way in which the DIFC law, which becomes important, is different. And the DIFC law itself says that where no seat is specified, if DIFC is the governing law, then the DIFC will be the seat. So we had the idea going back to 2008 of the DIFC as a default seat. So we've had then case law in the DIFC itself. The first is quite interesting. There was no seat at all specified in the arbitration agreement there, but nevertheless the court stayed the proceedings for arbitration. In that case, I think they were ultimately to take place in the United States. Then an interesting decision on capacity, where in fact the Court of Appeal of the DIFC decided both as a matter of DIFC law that there was apparent authority on a manager of a company to enter into an arbitration agreement, which is the common law default position. But they actually decided that it was also the position under Dubai law, although that has not influenced the Dubai Court of Cassation in any way. In that case, though, we just look at the analysis of the arbitration agreement. And the Court of First Instance there, so the seat of the DIFC and DIFC LCIA arbitration, and they said, therefore, DIFC law governed the arbitration agreement. So the Court of First Instance was looking both at seat and rules to decide that DIFC law governed the arbitration agreement. And that's how they found that the executive managing director had authority. But actually, the Court of Appeal was a little wiser than that. They ducked the issue entirely. And they said, well, if DIFC law applies, then there's apparent authority. If UAE law applies, then they actually found authority in fact. So it remains unclear after that case under DIFC law whether what the test was going to be applied. But then we have a more recent case, and counsel in that case, so Salman QC is with us today, Triple Y against Triple Z. And this is where we started having the problem that arose between the DIFC and the Court of Cassation. So, in fact, the Court of First Instance refused to recognize a judgment of the Court of Cassation, holding an arbitration agreement invalid on this incapacity issue, because the seat was actually the DIFC in that case. The matrix contract, the underlying contract, was subject to English law, and so the arbitration agreement following the ENCA approach was subject to English law, and the judge in that case, Richard Field, did follow that approach even before ENCA. But the Dubai court did not apply English law to the arbitration agreement, and he found on Sullivan's submission that was a breach of the New York Convention. The New York Convention is mandatory in terms in Article 2.3. The court shall refer the parties to arbitration unless it finds the agreement null and void, inoperative, or incapable of being performed. And when you read that with 5.1a of the New York Convention, that inoperability has to be found under the law applicable to the parties or under the law to which the parties have subjected it. So he found that the parties had actually subjected it to English law, and so consequently, he refused to recognize as right in law the Dubai Court of Cassation's decision. And then we have a later decision, where the unfortunate party fell between two stools, because again, the Court of Cassation had adopted the theory, which, put it mildly, is an unorthodox theory, that actually the institutional rules, the DIFC institutional rules, decide which court has the power to oversee the arbitration. And in that case, the Court of Cassation refused to annul an award because it was a DIFC-LCIA arbitration, and they said the DIFC was a supervisory court. The unfortunate parties then came to the DIFC, and the DIFC said, no, we don't have jurisdiction to set aside the award because actually the seat was Dubai, as agreed between the parties. And so the two courts within the emirate are applying different and indeed conflicting tests. So obvious need for clarity. And that's why I say there's a positive takeaway that comes from this, because we then come to Decree 34, which is in two parts. We have the decree itself and then the DIAC statute. And we see the abolition of the two centers, DIFC-LCIA and DIAC 1.0, and they are again brought together in DIAC 2.0. And Article 6 says at B that the party will consider to continue and determine arbitration cases pending before them, but DIAC 2.0 will undertake supervision of such cases. And then Article 7 is interesting. Both the Dubai courts, the IFC courts, shall at the date of entry into force of this decree continue to consider cases, requests, and challenges pursuant to their respective procedures and standards in this respect. So at the moment you think, well, it might preserve that problem that we just highlighted before. But then you go to the article, Article 4, the DIAC statute itself, because we're only talking about cases that are now before DIAC 2.0. It would be different if it were an ad hoc case, but then this problem may not arise. And what that says is, in the case of an agreement by the parties to arbitration on the selection either of the emirate, so outside the DIFC, or the DIFC itself as the seat, then the arbitration agreement shall be governed by the provisions either of the federal law or DIFC law. So now Article 4 of the DIAC statute enshrines in legislation a seat theory of the applicable law to the arbitration agreement. And that solves the problem of the conflict that we have in the jurisprudence between the onshore and the offshore courts. And hopefully we will not be seeing cases where four parties fall between the two stools as they did in that case before the CFI of the DIFC. And we also come to another provision, which goes back to what I said before, that the default seat will now be DIFC if no seat is chosen. And indeed, the arbitration agreement will be governed by DIFC law. So again, the statute is solving the problem as to which law will govern the arbitration agreement. But there's the question that Hassan raised, which is still unclear, but I hope there's now guidance to it. So what's the position under DIFC law where there is no seat specified, but it's there's a reference to DIAC 2.0, and UAE is the substantive law. And the question that has to be answered, that even if the DIFC is the deemed seat, will DIFC law apply UAE law to the arbitration agreement, for example, in relation to capacity, with a possible different result than there would have been under DIFC law? So that's obviously something that I suspect will come before the court quite quickly. But I hope in that very fast canter through, you can see that there are some interesting times ahead. Can I just answer the one point that Hassan raised too about the administration of DIAC 2.0 and about the court? And I'm afraid I have a sort of slight worry about that, which is because of Article 10.2 of the UAE law, where, of course, somebody who is involved in the administration of an arbitral institution cannot accept nominations arbitrator under those rules. And consequently, if you're trying to recruit practicing arbitrators onto the court of DIAC 2.0, you may encounter some difficulties unless that is changed. But that's a federal rule. So again, work in progress. We have to see what happens with that. Thank you very much.
Yeah, so thank you very much, Michael. You have ended it on a high note with, I guess, further needed clarification in a way, and that gives us a lot of room, I guess, to open the floor for discussion. But I would just like maybe to caveat one point is that even though the decree did indeed, alongside the statute, obviously clarify the issue of the seat in the absence of a selection or designation of the seat by the parties, and I'm referring particularly to that famous JJC decision number 1 of 2018, where there was some form of a confusion between the applicable institutional rules and the impact they would have on the designation of the seat and the absence of the choice of the seat by the parties. But I do think that it would merit maybe clarification that the scope of the decree remains, however, limited to DIAC arbitration cases. So I think it also remains to be seen whether there will be some form of extended guidance to be taken from the decree so that the courts can also seek probably to extend the application of these provisions in terms of their jurisprudence. Nicholas, shall you try maybe and take a shot
Number one.
at
I think number one, number one, number two aligned.
Yes.
Because I mean the position under DIFC law where no seat specified was the position on the decree, which you've just said, which is that DIFC becomes the default seat.
Yeah.
And then following one would expect that if UAE substantive law governs the main contract,
Yes.
it should apply.
But then you get a different result from the result under what would be under DIFC law.
The whole problem.
Yes.
Because you know, in Kababji, we were refused permission to appeal on the question of issue estoppel. So, wanting to say that the Paris court, the court of the seat, had ruled and upheld the award, and therefore that should give rise to some issue estoppel in respect of the enforcing court and the New York Convention of 1415. And paragraphs 87 to 90 of the judgment, we have something new which is emerged in English law in respect of the way English law or English law derived enforcing courts when treated the convention, because they simply say, sorry, no. The question that was before the Paris court of the court of the seat was a question of French law as the law of the seat. And the question before this enforcing court is, in fact, a New York Convention question under Article 518. So we're applying a different system of law. But that leads me to think, well, Article 6 has become completely irrelevant, potentially, in English law, because when can you ever get a German to security now? Remember your case, your IPCO case in the Supreme Court.
Well, yes.
When can you ever get a German to security if your court says, well, I don't care about the risk of inconsistent decisions?
Well, I have to say, I was applying for security actually on Friday before the English courts on another matter. And the prevailing, and looking at the authorities and indeed the reaction of the judge, say the prevailing zeitgeist seems to be they don't like giving security at all under any case at the moment. So we'll have to see.
Well, so I don't know if anyone has any questions. Should open the floor.
I just have a comment on what you just said about this article. I would be very curious to read the judgment of the UK court, Because for me, in French law, the New York Convention, as it is ratified by France, it is French law. And this is the French attorney point of view.
Yes.
French law includes the New York Convention.
The international
Yes.
treaties actually.
Yes, as a matter of law without any enacting instruments.
Exactly. So you cannot just say and imply that they applied French law without the
Of
New
course,
York
I mean,
Convention.
if you think about it from a factual perspective, the issues, honestly, between before the French court, the same arguments were before the French court to annul the award, as were before the English court to resist enforcement. So as a matter of fact, there was no doubt that the issues seemed to be identical. It's just that what the UKSC said was that the French court must apply French law, even if that subsumes the New York Convention. But the New York Convention wasn't relevant there because it wasn't a foreign award being brought before the Paris Court of Appeal. It was an international arbitration award, not a domestic award.
International, but
made in Paris.
That's raised a really interesting point on a slightly off-beam recent decision of the DIFC courts, which I personally think is not right. But so, as you say, under French and civil law, an international convention becomes part of the law of the country, which of course it doesn't under the common law system. Now, I was involved in a case which had probably an unfortunate result. It was the enforcement of an arbitration, a $2 billion enforcement of an arbitration award, Pearl and Kurdistan. I represented Kurdistan. And we actually were able to say that under the Riyadh Convention, we could assert sovereign immunity. And the DIFC court hated that, but they were persuaded by me that the Riyadh Convention was incorporated as part of the UAE law under that doctrine of civil law, and they were bound by it. The issues come back again recently, and they have said, we have a different doctrine in the DIFC. So the Riyadh Convention is not incorporated directly into the law of the DIFC, and so they refuse to allow the sovereign immunity defense under the Riyadh Convention. In a recent case, don't get me going on that issue. But but transferring it to what you said at the moment, maybe the possibility of a different analysis of the New York Convention between offshore and offshore laws on that analysis.
Dr. Yusuf, I think.
Well, I didn't raise my hand, but I have a lot. But I mean, I'm Yusuf Farah. I'm an associate professor at the University of East Anglia, and I teach international.
And as well, you are supervisor for my PhD. It's a compliment for us.
It's a compliment to me as well.
I'll have a word with you about that.
I'm not responsible. The issue to my mind, ultimately it was a question. I mean, two issues were quite prominent in the decision of Kibach, other than the brilliant name now, which brings smiles to the faces of my students when I teach them about the case, is the fact that two issues. Firstly, it's a conflict of law issue to begin with. And the second is that the very existence of the arbitration agreement was at stake. And so you could see here it's not the end in my view, because the implication of the choice of law to govern also the arbitration agreement can be displaced. In my view, I think this is how I understand the case. And we've seen a very brilliant example under the DIFC, the new degree, where it could be displaced based on the actual express words contained in the decree. The second issue is that you'll have to understand that where the English court is coming from, because I've been teaching English contract law for 15 years, and I'm quoting the case of high trees, for example, that you can't create for a contract by estoppel, promissory estoppel, and all of that. But what's happening over there is replacing a party into the contract and forming a new contract in a sense. And the English court had to be convinced that the the basic elements of the contract were there. So I'm just trying to explain as well what went into the mind of the Lord Justices is they're bound by years and years of precedence about formation of agreements. So that's my own comment. But my question to you there is one of the issues which has arisen in the case, which I found to be, maybe because I'm mostly academic, is the fact that the court said on the issue of validation that very basic principle of conflict of law, that you can't choose a law which is going to invalidate the contract. To my mind, that's a very strong point which came from the parties who were enforcing the work. But then the English said, well, wait a minute, that will not apply to the formation issue, because the very formation of the agreement was at stake. And I would love to hear your views about this, because I think this is bound to create new problems in the future, not only for arbitrators, but also in the context of international litigation.
Sorry, in very simple terms, doesn't it mean that, whenever you have a question about whether an arbitration agreement extends to a non-signatory party, you're going to know that under English law, there is a 99.9% chance that it can't.
Can I, the reason I wanted to put Article 4 again, so you see, we're dealing with the question, no seat, but it's UAE law and the DIFC court are dealing with it. That's the situation we're dealing with. So DIFC is deemed seat, the arbitration agreement shall be governed by DIFC law. So there's a conflict there between the common, because DIFC would normally follow Kababji and Enka, and they would say, if the law of the contract is UAE law, then the law of the arbitration agreement is UAE law. But the statute itself is saying that law of the arbitration is DIFC law. So at the moment, again, we don't know where they're going to go. And one of the things we do not know, actually, and this is quite fundamental, is whether the DIFC courts would regard themselves as bound by this statute in any event, even in relation to a DIAC 2.0 arbitration, because of course there is an exemption of the DIFC for all civil and commercial laws of the Emirates. So it may be that they may say, I'm sorry, this doesn't actually bind us at all. We're going to apply English. English we can choose, or Australian. There are Australian, very senior Australian judges that it's open to them to choose the law that they think is the most appropriate to the particular issue. So it is a trifle uncertain.
Yeah. I'll just maybe conclude by one last question before I go to Hafiz. But just wanted to say that we can definitely see that it's been. I find it quite fascinating and extraordinary that for such a fundamental yet simple question, which is which law governs the arbitration agreement, there is just still so much uncertainty, not only in the UAE as we've seen, but also at a global level. And we've seen with the Enka decision that even within one jurisdiction, there has been also within the ambit of the same court, there's been also several ramifications and directions. And we also see it very helpfully through Nicholas' presentation, different approaches at a global level with respect to the four sort of doctrines that govern the law governing the arbitration agreement, even though there's a unity, there's supposed to be unity in the provision under Article 5.1a of the New York Convention. So maybe by way of a conclusion, Hafiz, what can arbitral institutions maybe try to do to help achieve certainty?
With my institutional hat, I'm very glad you've asked the question. And there are a few institutions that have looked at the question. And having found my slides, I'll skip the debate on the New York Convention to start with this one. In 2014, the HKIC, in its model clauses, proposed that parties consider the question of the law applicable to the arbitration agreement. And the SAR explains to parties why it's something they may want to consider. They won the GAR Award for innovation for this, And at about the same time, the LCIA was amending its own rules. And the relevant article you want is 16.4, which is an amendment of the earlier 16.3, where they say the law applicable to the arbitration agreement shall be the law applicable at the seat subject to the parties' agreement. The reason why I put 16.2 is because the LCIA rules provide for a default seat if none has been chosen by the parties. This is the wording of the 2021 version of the LCIA rules, and Delos has also just updated its rules. Article 8 focuses on the arbitration agreement, and the first two paragraphs look at the same issue. 8.2 says, if there is no choice of the parties, then it will be the law of the seat. And the default seat is, under 8.1, the one best suited in the circumstances to the dispute. So that's what arbitration institutions can do, is to provide some certainty, some direction. I think at personal level, I would tend to think it's something more for the rules than for the agreement, because if you rely on the parties to cast their mind to the question and then make an informed decision, most likely you're not going to get what you need versus having a default position in the rules.
And hence, I guess, the helpfulness sometimes of resorting also to a sort of backfall position in terms of an institutional framework that would typically also fill in the gap of the legislative framework, which can sometimes result in uncertainty, as we've seen. So on that note, we will wrap up this session. Thank you very much for everyone, and we can continue definitely this discussion over lunch in the room just right across from us. So please do join us for lunch, and thank you once again for your attention.